The morning after my grandfather's funeral, my father dragged a metal barrel into the backyard and started burning his mail. Not the junk mail, not the catalogs and the grocery circulars and the credit card offers that accumulate on any elderly person's kitchen counter. Everything. Every envelope that had arrived in the weeks before he died, and every one that had come since. Bank correspondence, insurance notices, envelopes from attorneys, government mail with the specific formatted return addresses of federal institutions. He pulled them from the basket by the front door in stacks, and he carried them to the barrel, and he fed them into the fire with the focused efficiency of someone who has been waiting to do this for a long time. I watched from the kitchen window. Then I went outside and I said, "Dad, that's federal mail." He looked at me across the barrel with the specific expression he had used my whole life, the expression that communicated that I had said something stupid and he was deciding whether to correct me or ignore me. He said, "Dead people don't need mail." Then he looked at me for one more moment and he said the other thing, the thing he had been saying in various forms for 26 years, the sentence that was the family's running summary of their opinion of me. "You're worthless, Claire. None of this was ever meant for you." He went back to the fire. My mother came through the back door with another armful of envelopes and laughed at something my brother Ryan said, and none of them looked at me again. I believed every letter was gone. Then I found one envelope hidden beneath my grandfather's workbench. 3 months later, my father was sitting in a courtroom trying to explain to a judge why he had burned federal mail the morning after his father-in-law's funeral. Welcome back to Revenge Cold Stories. Subscribe before we go further, and now let me take you all the way back, because the envelope beneath the workbench is not where this story starts. This story starts with a man who spent the last years of his life watching his family very carefully, writing things down, and making arrangements that were specifically designed to survive them. My name is Claire Morgan. I am 29 years old. I am a paralegal in Columbus, Ohio, and I have been doing this work for 5 years with the specific precision of someone who chose a profession that rewards attention to detail because she grew up in a family that punished it. My grandfather was Harold Morgan. He was 78 years old when he died. He had spent his working life as a machinist in a mid-sized manufacturing operation in central Ohio, 41 years at the same plant, starting on the floor at 19 and retiring at 60 as the senior floor supervisor, the man who knew every machine in the building by sound and who could diagnose a mechanical problem from 40 feet away by the quality of a vibration. He was precise. He was methodical. He had the specific patience of someone who has spent 40 years working with systems that require exact tolerances and who understands that the difference between something working correctly and failing catastrophically is often a single measurement done carefully versus carelessly. He was also the only person in my family who had ever looked at me and seen something worth seeing. This is not a dramatic statement. It is an accurate one. I grew up in a family where the distribution of warmth had a clear hierarchy. My brother Ryan at the top, my parents somewhere in the self-focused middle, and me at the bottom in a position that had been assigned before I was old enough to have done anything to deserve it. I was the younger child, the one whose arrival had not been planned, the one my mother had described on more than one occasion as a surprise, in the specific tone of voice that meant something other than a pleasant one. Harold never accepted this hierarchy. He noticed it and he rejected it quietly, consistently, across the entirety of my conscious memory. The workshop was where we were together, in the basement of his house in Lancaster, Ohio, a house he had owned for 43 years, a 3-bedroom ranch on a corner lot where the backyard had enough space for a garden he maintained until his knees made kneeling painful, and then maintained anyway because the garden was his, and he was not going to let his knees decide what he did with it. The workshop was organized the way he organized everything, absolutely. Tools on pegboard, labeled, supplies in drawers that were also labeled, with small printed cards and plastic holders that named the contents and the quantity. A workbench with a vise that he had installed himself when he was 32, the bolts still solid because he had torqued them correctly and checked them every year. He taught me to use the tools when I was 7, not in the way adults sometimes teach children, performing patience while waiting for them to get bored. Actually teaching me, explaining the specific function of each thing, the correct grip, the reason the technique worked. He treated the information as serious because it was serious, and because treating a 7-year-old as capable of understanding serious information was, to Harold, simply accurate. He said once, I was 11, I had made a small wooden box with a lid that did not quite align. He said, the lid doesn't fit because the measurement was off by a 16th on the third cut. Not because you're bad at this, because a 16th matters. Now you know. That was how he taught everything. Not you failed. Here is specifically what happened and why, and what you know now that you didn't know before. I have been a paralegal for 5 years. I am precise and methodical, and I notice what is missing as readily as what is present. I owe this entirely to a man who believed that a 7-year-old girl was worth teaching carefully. My father's name is Daniel Morgan. He is 54 years old. He married my mother Susan 30 years ago, which means Harold was his father-in-law for 30 years, and the relationship between them was the relationship of two men who had decided to be civil for the sake of the family, and had both understood, across those 30 years, that the civility was the full extent of what was available. Daniel is the kind of man who measures his own worth by what he controls. He is not successful in the financial sense. He has worked a series of middle management positions across 20 years, each one held for 3 or 4 years before something went wrong with a supervisor or a policy, and he moved on. What he has is the family. The family is the context in which he is the authority, and the authority is the thing he has organized his identity around. Harold's money, the house, the pension, the modest savings account of a man who had worked 40 years and spent carefully, was something Daniel had been thinking about for a long time, not because the amount was life-changing, because inheriting it would mean receiving something from a man who had never fully respected him, and the receiving would feel, to Daniel, like a kind of retroactive validation. Harold had never left him in any doubt about where the inheritance was going. He had said it to Daniel directly, once, in the way Harold said difficult things, plainly, without cruelty, stated as a fact that the listener could do with what they chose. He had said, "When I go, what I have goes to Claire. You and Susan are employed and housed. Claire is building her life, and she did it without help from anyone in this family." Daniel had not argued. He had smiled the smile he used when he was filing something away for later. My mother Susan is 52. She has been in alignment with Daniel's worldview for 30 years, because alignment with Daniel's worldview is the domestic arrangement she chose at 22 and has never revisited. She is not the architect of anything. She is the support structure, the person who laughs at the right moment and shrugs at the right moment and looks away at the right moment. She has looked away from a great many things across 30 years. My brother Ryan is 31. He is 2 years older than me and has spent those 2 years treating the age gap as a credential. He got the warmth, he got the birthday parties and the college fund and the truck when he turned 18, and the general ambient assumption that he would be fine, because he had always been treated as someone who would be fine. He is not cruel in the creative sense. He is cruel in the passive sense, the cruelty of someone who accepts an unfair arrangement without examining it because the arrangement favors him. What they said about me across the years was a curriculum. You're worthless. You're the family mistake. Nobody would choose you. Grandpa only pities you. He doesn't actually love you. He just feels sorry for you because nobody else does. You're too stupid to inherit anything. Even the dog is more useful than you. You'll die broke. These things were said at dinner tables and in cars and at holiday gatherings where there were other people present who looked at the floor or found reasons to leave the room. They were said with the casualness of repetition, not in hot anger mostly, but in the specific cool tone of people stating what they consider established fact. Harold objected. Every time he was present and something was said, he objected. Not dramatically, not with speeches, but in the way he objected to everything that was wrong, clearly, specifically, without apology. He would say, "That is not true, and you will not say it in my house." He would say, "Claire is the most capable person in this family, and you know it." He would say nothing and simply look at Daniel with the look of a man who has taken a measurement and found it significantly short of specification. Daniel would roll his eyes. Susan would laugh at something. Ryan would mock whatever Harold had said. I would watch Harold absorb this, and I would watch him say nothing more, and I would watch him later in the workshop take out a notebook and write something down. I asked him once what he was writing. He was 69, I was 16, and the notebook had been appearing for about a year. He said, "Things I want to remember accurately." I asked why accurately. He said, "Because people rewrite things, especially after someone dies. They rewrite what was said and what happened and what was intended. I am making sure that what I witnessed and what I intended is written down in my handwriting with dates, so that if anyone tries to rewrite it, there is something to compare the new version against." He said, "The people who rush an inheritance usually don't deserve one." I did not fully understand what he was building at 16. I understand it completely now. He died on a Wednesday in March, a stroke in his kitchen in the morning. He had been declining for 8 months. The kind of decline that is slow enough to be manageable and continuous enough to be unmistakable. He had continued going to the workshop during those 8 months. He had continued the garden. He had continued the notebook. He had also, I would learn later, been in regular contact with an attorney. The funeral was on Saturday. It was a small service. Harold had requested small, which was consistent with everything else about him. The people who attended were the people who had actually known him, neighbors, 2 men from the plant who had worked for him and had driven 2 hours to be there, Mrs. Garrett from the church who had been bringing him a casserole every 3rd Sunday for 15 years. My family attended the funeral as a unit, Daniel in his good suit, Susan with the expression of someone performing appropriate grief. Ryan with his phone in his jacket pocket that he checked twice during the service when he thought nobody was looking. I sat in the front pew beside Harold's empty chair because there was not a front pew. There was just a row of chairs at the funeral home, and I sat in the first row and I held on to the arm of the chair, and I did not let go of it for the entire service because letting go of it was the only thing I was managing, and managing it took everything I had. Afterward, at the house, the family moved with the efficiency of people who had a plan. Sunday morning, the morning after. I woke up in my childhood bedroom. I had stayed at the house, Harold's house, because I could not make myself leave the night before, and nobody had told me to go. Not yet. I could hear my father in the backyard before I was fully awake. A specific metallic sound, the barrel being dragged across the flagstones. I went to the kitchen window. He was already at the basket by the front door. He had it tucked under one arm, and he was carrying it toward the back door, and then through it, and then across the yard to the barrel. He dumped the basket into the barrel. He went back inside. He came back with a box, the box from Harold's office where the incoming mail had been piling up for the past month of the decline, when Harold had not been managing correspondence himself. My mother followed with an armful of envelopes she had apparently collected from the bedroom. Ryan came behind her with a stack of papers he had pulled from somewhere, his shredder already audible from the office. I went outside. Daniel looked at me across the yard the way he always looked at me when I was about to object to something, with the preemptive contempt of someone who has already decided that what I say will be irrelevant. I said, "Dad, that's federal mail." He said, "Dead people don't need mail." I said, "Some of those are from attorneys." "You can't burn attorney correspondence. That's destruction of legal documents." He looked at me for a moment with the expression that had been my whole childhood, compressed into 5 seconds. He said, "You're worthless, Claire. None of this was ever meant for you." He turned back to the fire. My mother came through the back door with the last armful and laughed at something Ryan had said from inside the house. Neither of them acknowledged me. The fire was efficient. The dry envelopes caught immediately. The papers behind them caught. The entire correspondence of a dead man's final months was gone in less than 10 minutes. I stood in the yard and I watched the fire, and I did not argue further because I am a paralegal and I understood, watching the smoke, that what Daniel had just done was not the end of something. It was evidence. I went inside. I went to the workshop. I do not know specifically why I went there, some combination of habit and grief, and the understanding that if Harold had left anything for me to find, the workshop was where he would have left it. I went down the basement stairs. I turned on the light. The pegboard was intact, the labeled drawers, the workbench with the vise. I stood in the middle of the workshop for a moment the way I had stood in it hundreds of times. Then I looked at the floor, beneath the workbench in the far right corner where the shadow was deepest, where the corner of the bench met the wall, a white envelope. It had apparently fallen or been placed in a position where the morning's collection had not reached it. The corner of the workbench had hidden it from above. I crossed the workshop. I crouched down. I picked it up. It was addressed to Harold Morgan. Personal and confidential was printed on the front in bold. The return address was a law office in Columbus, Ohio. It was sealed. It had never been opened. I turned it over in my hands. I looked at it for a long time. The envelope was slightly dusty from the floor, one corner bent from where it had been against the baseboard. I put it in my bag. I went upstairs. Daniel was in the kitchen making coffee like it was a normal morning. Ryan was on his phone at the table. My mother was already looking at the contents of a hutch in the dining room with the evaluating expression of someone deciding what to do with furniture. Nobody looked up. I walked through the kitchen. I walked through the front door. I got in my car and I drove back to Columbus with the envelope in my bag and the smell of burned paper on my jacket and the specific, focused calm of someone who has understood that the situation has just become something different from what everyone in that house believes it is. I drove back to Columbus with the envelope on the passenger seat, not in my bag. I had taken it out at the first red light and set it beside me because I wanted to be able to see it. This sounds irrational, and it was not irrational. It was the specific instinct of someone who has just recovered a piece of evidence from a crime scene and understands, at a professional level, that the evidence is the most important thing in the car and should be treated accordingly. I did not open it driving. I did not open it when I got home. I parked in my apartment building's lot, and I sat in the car for 4 minutes, and I looked at the envelope on the passenger seat. The bent corner, the dust from the workshop floor, the personal and confidential in bold across the front, the Columbus return address, and I made a decision about the order of operations. First, photograph it unopened. Document the condition it was in when I found it. Second, read it. Third, based on what it contained, determine next steps. This is how I approach everything at work. This is how Harold approached everything in the workshop. You do not skip steps because skipping steps produces outcomes that could have been prevented by the step you skipped. I went upstairs. I took 6 photographs of the envelope from different angles: front, back, both sides, the postmark, the return address. I noted the date I had found it and the circumstances in a document on my computer, time-stamped, because a paralegal's first instinct when something is going to matter later is to create a contemporaneous record of when and how it came to exist. Then I sat at my kitchen table and I opened the envelope. Inside, 3 pages and a business card. The business card first. I always look at the business card because it tells you immediately who you are dealing with. Margaret Holloway, Estate and Trust Law, Holloway Legal Group, Columbus, Ohio. The card had the weight and finish of someone who had been practicing long enough to invest in good stationery. The first page was a cover letter, dated 6 weeks before Harold's death, addressed to Harold at the Lancaster address. The salutation was formal, "Dear Mr. Morgan," and the first paragraph was the kind of opening a careful attorney writes when they want the record to reflect that this communication was made and when. The letter said that per Harold's instructions, she was enclosing the trust activation package for the Morgan Family Trust, established 7 years prior. It said that in the event Harold was unable to respond to this correspondence within 30 days, the trustee contact information should be considered operative, and the trust should be treated as active per its terms. It said that copies of all trust documents were maintained at her office and that a duplicate set had been filed with a second attorney in Zanesville, Ohio, at Harold's specific request, a second attorney. In a different city, I read that sentence twice. The second page was what the letter called the Trust Activation Summary, a 4-paragraph document that explained the trust's basic structure in plain language. The Morgan Family Trust had been established 7 years ago with Harold as the initial trustee. Upon Harold's death, the successor trustee was named as Claire Morgan, granddaughter, contingent on her willingness to serve. The trust's assets included the house at the Lancaster address, the contents of 2 bank accounts whose last 4 digits were listed, and a portfolio of modest investments. The trust's primary beneficiary was Claire Morgan. I looked at the wall across from my kitchen table for approximately 30 seconds. Then I read the 3rd page. The 3rd page was the one that told me Harold had understood exactly what was going to happen. It was a notarized letter signed by Harold 14 months before his death, addressed to Margaret Holloway and any court of competent jurisdiction that might eventually review the trust documents. It said, in Harold's specific, plain-spoken way, "I am writing this letter because I have reason to believe that my family may attempt to interfere with my estate following my death. I am documenting this concern now, while I am in full possession of my faculties, and while the concern is anticipatory rather than confirmed, so that if the concern proves founded, this letter constitutes contemporaneous evidence of my awareness." He described what he had observed across the preceding years. Mail that had arrived and then was not where he had placed it. Documents from his financial accounts that he had not moved, but that were found in different locations. Conversations with family members in which they had asked questions about his estate that he had not answered directly and had found concerning in their specificity. A period during which he had received no response to letters he believed he had sent, which he later discovered had been intercepted before leaving the house. He wrote, "I have taken the following steps to protect the trust and its intended beneficiary." He listed them: the duplicate documents filed with the Zanesville attorney, a recorded conversation with a neighbor who had witnessed certain events, notes maintained in a workshop notebook, copies of financial statements kept in a safety deposit box at a bank branch he had not used for regular banking, specifically to reduce the likelihood of family access. Then the last paragraph. He wrote, "If anyone has destroyed or attempted to destroy mail addressed to me following my death, I want the record to reflect that I anticipated this possibility and took steps accordingly. The trust is designed to survive interference with its documentation, because the primary documents are held at 2 separate law offices, and the successor trustee, Claire Morgan, has the legal authority to activate the trust upon presenting herself to Margaret Holloway with identification. No physical document held at my residence is required for trust activation. I have structured it this way deliberately. I read this paragraph 3 times. He had known, not suspected. Known, with the specific knowledge of someone who had been watching carefully and taking notes and drawing conclusions with the precision of a man who had spent 41 years working to exact tolerances. He had built the trust to survive Daniel burning the mail. He had been building it to survive Daniel burning the mail for 7 years. I called Margaret Holloway's office at 9 the following Monday morning. Her assistant put me through when I said my name. The speed of the connection told me the same thing the assistant's immediate recognition of my name told me. I had been expected. Harold had told her to expect me. She said, "Claire Morgan." I said, "Yes." She said, "I have been waiting for your call. Your grandfather told me you would call within a week of finding the envelope. He said if I had not heard from you within 2 weeks, I should contact the Lancaster Police Department." I said, "He planned the envelope." She said, "He placed it there 6 weeks before he died, during a visit to the house when your father and mother were not present. He told me exactly where he was putting it and why. He believed that if any mail was destroyed, that particular location under the workbench was unlikely to be thoroughly searched because it required getting down on the floor. He said your father was not the kind of man who got down on the floor." I had a specific feeling when she said this, not humor, something more complicated. The image of my grandfather, at 77, on his knees on the workshop floor, carefully positioning an envelope in the corner under the workbench because he knew his son-in-law and he knew the floor. I said, "He mailed other copies to that address. They were burned." She said, "I know. I sent 4 pieces of correspondence to the Lancaster address over the preceding 3 months. I received no response to any of them. I sent the first one as a routine trust administration update. When I received no response, I sent a second with a read receipt request. When the receipt came back unsigned, I began to keep records. When the 3rd and 4th went unanswered, I flagged the file." She said, "Mr. Morgan had told me specifically that non-response to my correspondence should be treated as a potential indicator of interference. He had asked me to document each unanswered communication and to note the date and content. She had done it, 4 letters, 4 dates, 4 contents, all documented in her file. I said, "My father burned everything the morning after the funeral." I watched him do it. She was quiet for a moment, then she said, "Can you come to my office today?" I said I could be there in an hour. Margaret Holloway's office was on the 14th floor of a building in downtown Columbus with the specific professional calm of a space that has been organized to make clients feel that whatever problem they have brought is manageable. She was in her mid-50s, the kind of attorney whose office reflects a practice long enough established that the art on the walls is real and the coffee is good. She shook my hand. She looked at my face the way someone looks when they are comparing you to a description they have been given. She said, "He talked about you a great deal." I said, "What did he say?" She said, "He said you were the only person in your family who read the whole document before you signed it. He said he had tested this by giving you a lease renewal when you were 22. He pretended he needed a second opinion, and you caught 2 clauses he had flagged himself. He said, 'That's the one who will know what to do with this when the time comes.'" I looked at the window behind her desk. The specific distance between 22 years old being handed a lease renewal and 29 years old sitting across from an estate attorney in Columbus, and the man who had managed both moments with the same methodical forward planning. She opened the file. What Margaret had was comprehensive in the specific way of a case that has been built by someone who understood the legal system well enough to know what it would eventually need. The trust documents, original and complete. Established 7 years ago, when Harold had first noticed that documents in his house were not always where he had put them. He had not told anyone about the trust. He had paid the legal fees from a separate account he had opened for this purpose, at a bank where no family member had ever been added to his accounts. He had maintained this separation for 7 years. The unanswered correspondence log, 4 entries, each with date, method of sending, content summary, and the notation "no response received." The 3rd entry had an additional note: attempted phone contact at primary number, reached voicemail, left message, no callback. Harold's written statement, the notarized letter I had found in the envelope, but Margaret had the original properly executed with all formalities. She had witnessed him sign it. She had noted his demeanor at the signing in her file. Client appeared fully oriented, expressed himself clearly and specifically, demonstrated detailed knowledge of the documents and their purpose. The Zanesville attorney, a man named Robert Chen, who had received his copy of the trust documents 18 months ago and had been instructed to hold them and to cooperate with Margaret's office in any proceeding arising from the estate. Margaret had already contacted him. He was standing by. I asked about the burn barrel, whether witnessing the destruction of mail constituted something actionable. Margaret set down her pen. She said, "Destroying mail addressed to a deceased person that includes legal correspondence is a serious matter. Federal law covers the destruction of mail. Ohio law covers interference with estate proceedings. The specific act of burning attorney correspondence that contained trust activation documents, combined with the documented pattern of non-response to 4 prior communications, creates a record that a probate court and potentially a federal prosecutor would find significant." She said, "What I need from you is a statement, what you saw, when you saw it, in your own words. I need it in writing, and I need it detailed." I said, "I'm a paralegal. I know how to write a statement." She said, "I know. Your grandfather told me that too. I spent 3 hours in her office that afternoon. The statement took 90 minutes. I am precise, and I write precisely. And the statement was 16 paragraphs covering the morning of Sunday, the barrel, the specific categories of mail I had observed being burned, the exchange with Daniel, the workshop, the envelope, its condition when I found it, the photographs I had taken, and the chain of custody from the workshop floor to Margaret's desk. She reviewed it while I was still in the office. She asked 2 clarifying questions. She made no changes. Then she told me what came next. She was going to file the trust activation with the probate court. This was a standard proceeding. The trust existed. The successor trustee was present and willing to serve. The documents were in order. The court would be asked to confirm the trust's validity and my authority as successor trustee. At the same time, she was going to contact the Postal Inspection Service. Destruction of federal mail is a federal matter, and she had an obligation, she said, to report what I had described. She was going to report it. She said, "This is not a tactical decision. This is what I am required to do." She was also going to contact local law enforcement about the estate interference, the burning of attorney correspondence, the specific prohibition against interfering with estate proceedings, the documented pattern of non-response that her office had recorded. She said, "Your grandfather wanted the trust protected legally. This is how you protect it legally, not through confrontation, through the proper channels, in the proper order, with proper documentation." I said, "That's exactly what he would have said." She said, "I know. He said something similar to me when we drafted the trust 7 years ago. He said, 'Margaret, I don't want to fight. I want a record so complete that a fight becomes unnecessary.'" While I was in Margaret's office on Monday, my family was in Lancaster doing what they had been doing since Sunday morning. Ryan had listed Harold's truck on a marketplace website. The listing went up at 11 a.m. I know because I had created an account that morning with a name that was not mine and had been monitoring the estate-related platforms, which is the kind of thing a paralegal does when she understands that a situation is developing and that documentation of the situation's development matters. My mother had called a consignment shop about the furniture. She had photographed the hutch and the dining room table and 2 pieces from the bedroom and had sent the photos to the shop's email. I know this because she had sent the photos from a phone she did not realize was still logged into a shared family cloud account that I had been added to 3 years ago and had never been removed from. My father had called the bank. Not Harold's primary bank, the secondary account, the one Margaret had mentioned that Harold had opened for trust-related expenses. He had called asking about the balance and had been told by the branch that he was not an authorized account holder and could not receive that information. He had apparently found this surprising. He had called back. He had been told the same thing. I know he called back because Margaret had contacted the bank that morning to notify them of the pending trust proceeding, and the branch manager had noted the 2 calls and passed the information to Margaret's office when she identified herself as the trust attorney. My father had called a bank where he was not an authorized holder twice in one morning asking about a balance in a dead man's account. This would become significant later. On Wednesday, 5 days after the funeral, Margaret filed the trust activation with the probate court. The filing was routine on its face. A successor trustee presenting herself with documents establishing a valid trust and requesting confirmation of her authority. The documents were in order. The trust was 7 years old and had been properly established and maintained. There was nothing irregular about the trust itself. What was attached to the filing was the statement of concern. Margaret's documentation of the 4 unanswered correspondence attempts, my witness statement about the burn barrel, the photographs I had taken of the envelope in its condition when found, and Harold's notarized letter anticipating interference. The probate court received this on a Wednesday. By Thursday, the Postal Inspection Service had received Margaret's report. By Friday, the Lancaster County Prosecutor's Office had received a referral regarding potential estate interference. My family did not know any of this was happening. They were in Harold's house, making decisions about furniture and trucks and bank accounts in the specific confidence of people who believe they have successfully managed a situation and are now collecting its benefits. Daniel had told Ryan on Sunday, while the barrel was still smoking, "We handled it. There's nothing to find." He had said this in Harold's kitchen, which had a window that faced the backyard, which was where the barrel was, which was 12 feet from the workshop door, which was 22 feet from the corner under the workbench where a white envelope had been sitting untouched for 6 weeks. He had been wrong about one envelope. He was about to find out what one envelope could do. The probate court scheduled the initial hearing for 6 weeks after Margaret's filing, 6 weeks during which my family continued to operate on the assumption that the situation had been handled. Ryan's listing for Harold's truck had generated several inquiries. I know because I was still monitoring the marketplace platform, still documenting the same way I had been documenting since the morning of the burn barrel. My mother's consignment shop conversation had produced an appointment. My father had made 2 more calls to the bank where he was not an authorized holder and had been refused twice more, each refusal noted by the branch manager and passed to Margaret's office. Each thing they did in those 6 weeks was a documented action taken against an estate that was no longer unprotected. I did not contact them during this period. Margaret had been clear about this, and I had agreed before she said it because I understood the principle from 5 years of paralegal work. You do not contact the opposing party when a legal proceeding is developing. You let the proceeding do what the proceeding is designed to do. I went to work, I came home, I called Margaret twice a week for updates. I maintained the document on my computer that recorded every development with timestamps. Not because Margaret asked me to, because Harold had taught me that the things worth remembering are worth the 30 seconds it takes to record them, and everything happening now was worth remembering accurately. The Postal Inspection Service moved faster than I expected. A postal inspector contacted me 12 days after Margaret filed the report. His name was Agent Torres. He was professional and specific in the way of someone who conducts these investigations regularly and who does not editorialize about what he is told. He asked me to describe what I had witnessed on the morning of the Sunday after the funeral. I described it exactly as I described it in the statement. The barrel, the basket, the box from the office, the stack Ryan had carried from the bedroom, the specific categories of envelopes I had observed, the exchange with Daniel, the statement he had made to me about dead people not needing mail. Agent Torres made notes. He asked clarifying questions that told me he was building a specific picture, not collecting general impressions. He asked, "In your professional judgment as a paralegal, did you recognize any of the mail categories being burned as categories that would typically contain legally significant correspondence?" I said yes. I recognized the format of federal government envelopes, bank correspondence envelopes, and what appeared to be attorney letterhead visible on one piece before it went into the barrel. In my professional experience, those categories would routinely contain documents that have legal significance to an estate proceeding. He asked, "Did you observe any attempt to determine the contents of the mail before it was burned?" I said, "No. It appeared to go directly from the collection points into the barrel without being opened or reviewed." He said he would be in touch. He was in touch 11 days later with a follow-up question about the specific time of morning, which I answered from the notes I had made on the day. He was in touch again 14 days after that to tell me that the investigation had expanded and that I would likely be contacted about providing a formal statement to his office. I said, "I have a written statement already prepared." He said he knew. Margaret had provided it. He said it was thorough. My father called me on a Thursday evening 33 days after the funeral. He had received a notice from the probate court. The notice informed him, as a family member of the deceased, that a trust proceeding had been initiated and that a hearing was scheduled. It listed Margaret as the filing attorney and me as the successor trustee named in the trust documents. The call lasted 4 minutes. His voice had the specific quality of someone who is trying to determine how much you know before deciding how to respond to what they now know you know. He asked about the trust. He said he had not been aware there was a trust. He said Harold had never mentioned a trust. I said, "Harold kept his affairs organized. Margaret Holloway has the documents." He said, "This is a mistake. Harold didn't have the mental capacity for something like this at the end." I said, "The trust was established 7 years ago. Harold's capacity 7 years ago is documented in Margaret's file, including her notes from the signing meeting." A pause. Then the sentence he had been building toward since he first heard about the trust. He said, "You put her up to this. You've been manipulating him for years, getting him to cut out his real family." I said, "I'll see you at the hearing, Dad." I hung up. I opened my computer. I documented the call. Time, duration, content, the specific claims he had made. I noted that he had raised the issue of Harold's capacity unprompted, which Margaret had told me was a predictable tactic, and one that the documentation from 7 years of trust administration was specifically designed to address. I sent Margaret the notes before I went to bed. She replied at 7 the next morning, noted and filed. "Thank you." The probate hearing was not a trial. I want to say this clearly because people expect legal proceedings to have the drama of television, and this hearing was not that. It was a probate court session in a courtroom in Columbus, in front of a judge who had been reviewing trust documents for 20 years and who had, in Margaret's assessment, a very low tolerance for proceedings where the documentation on one side was organized and the other side had arrived unprepared. Margaret represented me. My father had retained an attorney, a man whose name I will not use here, who practiced general law in Lancaster and who had clearly not anticipated the depth of what Margaret's filing contained when he agreed to take the case. The first 20 minutes were procedural. Margaret presented the trust documents, the originals, witnessed, notarized, dated 7 years prior, the Robert Chen copies from Zanesville, independently held, matching the originals exactly, the trust activation summary, Harold's notarized statement of concern. The judge reviewed them with the specific, focused attention of someone who reads documents for a living and can tell, from the quality of the paperwork in front of them, how carefully it was prepared. Then Margaret presented the correspondence documentation, 4 letters to the Lancaster address, dates, contents, return receipts, the notation no response received on each one, the branch manager's records of my father's calls to Harold's secondary bank account, 2 calls, 2 refusals, both dated before any public notice of the trust proceeding had been filed, which meant he had known to call that specific bank before the trust's existence was a matter of public record. The judge looked up at that last document. She asked my father's attorney to explain how his client had known to contact that particular bank account before the trust proceeding was filed. My father's attorney said he would need to consult with his client. The judge said she would wait. The consultation lasted 3 minutes. Then the attorney said his client had found a reference to the account in Harold's personal papers. The judge asked when he had reviewed Harold's personal papers. The attorney said, the morning after the funeral. The judge made a note. Margaret then presented what she called the mail evidence section of her filing. My witness statement. The 6 photographs of the envelope, the dust, the bent corner, the postmark, the personal and confidential notation, the return address. Agent Torres' report from the Postal Inspection Service, which documented his investigation and included his own notes from our interviews. The judge reviewed the photographs. She looked at the postmark date on the envelope, the date it had been sent, which was the same date as the 4th piece of Margaret's correspondence to the Lancaster address. She asked my father's attorney, "Is your client disputing that mail addressed to the deceased was destroyed on the morning of the day identified in this statement?" The attorney consulted with my father in low voices for approximately 90 seconds. He said, "My client acknowledges that some materials were disposed of, but maintains that this was routine cleanup of personal correspondence and that he was unaware of the legal significance of the materials." The judge said the return address on this envelope, which counsel can see in the photograph, identifies it as correspondence from an estate and trust law office. "Is your client maintaining that he did not recognize legal correspondence when disposing of it?" More consultation. The attorney said, "My client did not review the envelopes individually before disposal." The judge said, "So he burned legal correspondence without reviewing it." The attorney did not have a useful response to this. The judge looked at the courtroom for a moment with the expression of someone who has reviewed the paperwork and reached a conclusion that the paperwork fully supports. She confirmed the trust. She confirmed my authority as successor trustee. She issued a directive requiring the return of any estate assets that had been disposed of or sold without probate authorization, specifically the truck, for which Ryan's marketplace listing had generated a completed sale 2 weeks prior. She noted the Postal Inspection Service matter and stated that the court would cooperate fully with any federal investigation arising from the documented mail destruction. My father's inheritance claims were denied. His attorney asked for a continuance to gather additional evidence regarding Harold's capacity at the time the trust was established. The judge denied the request. She noted that the trust had been active for 7 years, had been maintained and administered consistently throughout that period, and that the filing attorney had provided contemporaneous documentation from the establishment meeting establishing Harold's full capacity at signing. The hearing was 47 minutes. What came after the hearing moved on its own timeline, which is the honest way to describe how legal consequences work. They do not arrive simultaneously. They arrive in the sequence that the relevant processes produce them. The Postal Inspection Service completed its investigation 8 weeks after the hearing. The findings were referred to the federal prosecutor's office. My father was charged with destruction of federal mail, a federal offense under the relevant statute, specifically the intentional destruction of mail addressed to another person. The fact that Harold was deceased did not change the legal status of the mail, which had been addressed to him and had been in transit or delivered to an address where it awaited his receipt. He was also charged, under Ohio law, with interference with estate proceedings, the intentional destruction of documents material to a probate matter. Margaret's documentation of the 4 unanswered correspondence attempts, combined with my witness statement and the bank call records, established both the materiality of the destroyed documents and the knowledge of their existence prior to destruction. My mother was charged as a participant in the destruction based on Agent Torres's investigation, which had produced a statement from the neighbor across the alley, a man named Bill Garrett, who had seen the burn barrel from his yard on the morning in question, and whose statement described both my parents at the barrel and specified the categories of materials he had observed. Ryan's situation was addressed through the civil estate proceedings rather than criminal charges because the evidence of his specific knowledge of the mail destruction was thinner than the evidence against my parents. He was ordered to repay the estate the value of the truck he had sold, the sale price, documented from the marketplace transaction, plus the consignment shop items my mother had arranged for which the shop provided receipts. The total repayment ordered exceeded the value of most of Harold's liquid assets, which meant the estate was made whole and the family's anticipated inheritance was consumed by their own actions. My father's sentencing was on a Tuesday morning in November. I was in the courtroom. Margaret had asked if I wanted to submit a victim impact statement, and I had thought about it for 3 days and decided not to. Not because I did not have things to say. I had things to say that I had been accumulating since I was 3 years old. Because Harold had said, "Do not argue. Let the documents speak." The documents had spoken for 8 months. I did not need to add my voice to what the documents had already established. The judge who sentenced my father was not the probate judge. He was the federal district judge assigned to the mail destruction charge, a man in his 60s with the specific authority of someone who has been imposing consequences for a long time and who does not find them personally satisfying or distressing. He finds them appropriate or not appropriate, and he applies them accordingly. My father received a sentence that the federal guidelines supported. The Ohio state charges had been coordinated with the federal proceeding to run concurrently. My mother received a lesser sentence that reflected her degree of participation relative to my father's. I watched them leave the courtroom with the specific calm of someone who has been working toward a moment for 8 months and who discovers, when the moment arrives, that it is quieter than expected. Not disappointing, just quieter. The consequence. Landing with the flatness of something that has always been coming and has now arrived. I did not feel vindicated in the dramatic sense. I felt the specific relief of a process that had run correctly. I went to the house on Lancaster the following weekend. The estate administration had given me access as successor trustee, and I had been managing the property from a distance since the hearing, but I had not been back to the house itself since the morning I found the envelope. I went to the workshop first. The pegboard was intact. The labeled drawers, the workbench with the vise he had installed at 32 and checked annually for 46 years. The stool I had sat on every summer of my childhood watching him fix things and explain what he was fixing and why. I stood in the middle of the workshop for a long time. Then I went to work. I cleaned the bench. I reorganized the tools that had been slightly displaced. Ryan had apparently come down here at some point. I could tell from the 2 tools that were on the wrong hooks, which would not have been visible to anyone who did not know the system, but which were visible to me because I had been learning the system since I was 7. I put them back on their correct hooks. I set the framed envelope on the workbench beside Harold's photograph. I had framed it the week after the sentencing. The envelope itself, in the condition it had been in when I found it, the bent corner and the dust and the personal and confidential visible through the glass. I had added a small label at the bottom of the frame in the same compressed, precise font Harold used for his drawer labels. It said, "The one he missed," not for drama, for accuracy. It is on the workbench in the workshop in the house on Lancaster, beside his photograph, in the space where he made things carefully for 40 years, and where he placed one envelope in a corner where the shadow was deepest because he knew his son-in-law and he knew the floor. Here is the thing I understood, sitting on that stool in the workshop on the November afternoon when the case was closed and the family was gone and the house was quiet. My grandfather spent 7 years building something that was designed to survive the specific people he knew would try to destroy it. He did not do this in anger. He did not do it as revenge. He did it with the same methodical precision he brought to every problem he had ever encountered. He identified the failure mode. He designed around it. He tested the design by thinking through every scenario his knowledge of the people involved could generate. The failure mode was Daniel. The design was a trust with documents in 2 cities. The test was 4 unanswered letters. The envelope was the redundancy, the last backup, placed by hand in the corner he was certain Daniel would not reach. He was right about everything. He called me the only person in the family who read the whole document before signing it. He tested this when I was 22 with a lease renewal, and I caught both the clauses he had flagged. He built a 7-year legal structure on the conclusion that Tess produced. I have thought about this a great deal since November, about what it means to be seen accurately by one person when every other person in your immediate world has been looking at you and drawing different conclusions. About the distance between what my father said over a burn barrel, "You're worthless, Claire," and what Harold said to an estate attorney 7 years before his death. That's the one who will know what to do with this when the time comes. One of those assessments was built on 41 years of working to exact tolerances by a man who knew the difference between a measurement that was right and one that was wrong. The other was built on nothing except the need to believe it. The workshop is mine now. I come on Saturdays. I am learning the tools in the specific order he would have taught them, starting with the level, because he always started with the level, because you cannot build anything true without knowing what level is. The garden needs work. I am addressing it in sections, the way he addressed every large problem, one section at a time in the correct order, not rushing the parts that need time. The house is mine, and I am not rushing it either. Tell me your first name and your city in the comments. Tell me if someone built something for you that survived the people who tried to take it apart. Tell me if you found the envelope. Subscribe to Revenge Cold Stories, and I'll see you in the next one.